Hi, my name is Lauren Fields. I lead the domestic litigation team here at Roth Davies LLC. In this video, I'm going to be discussing hearings in front of the court. If parties cannot agree on something, for example, a temporary parenting time order, that would result in a court hearing. Anytime the parties reach a point of conflict where they cannot reach an agreement, that is taken up in front of the judge, and the judge decides for the parties. I always encourage my clients to try to work out an agreement with their spouse or their significant other or the parent of their child and attempt to work out an agreement that works for that specific family. As you can imagine, going in front of a judge is intimidating and you lose control that you have over the case. In order to get in front of the court on a motion, you must first have to file the motion. The motion can be titled for whatever the parties need to be titled. For example, perhaps it would be a motion to allow mother the ability to buy a house, regardless of the temporary order that says that neither party can take out a mortgage. If the other side doesn't agree with that request for her to buy a house, then we would get a court date after filing our motion and take that issue up in front of the judge. Then at the hearing, we would present our evidence supporting our argument, the result that we want, and then the other side would do the same. At the end of that hearing, the court will take into consideration both sides of the argument and perhaps ask some questions of the parties, then make a ruling. The ruling will be a court order that the parties have to follow. These motions can be filed during the course of the divorce or in the event that the parties have already finalized their divorce. They can always file motions to modify the controlling parenting time agreement. The important thing to remember is these hearings only go in front of a judge if the parties cannot agree on issues. Having an understanding of what's best for one's family is always important to consider before filing these motions. If I think my client is being completely unreasonable, I will tell them that. In my experience, a motion gets heard by the court when one of the two parties is being unreasonable. Typically, if the parties are within reason and thinking what's best for their families, most of these issues can be resolved without court intervention. Unfortunately, if they cannot reach an agreement, motions must be filed and the judge must hear the issue. If you have any questions on motion hearings, please feel free to give me a call at 913-451-9500.